There is a procedural tradition called the Rule of Four. It appears in no statute, no constitutional amendment, no federal code section, and it has silently decided which legal questions American courts are allowed to answer since 1925. No one voted for it. Congress did not pass it. The president never signed it. The 9 most powerful judges in the country made it up themselves, and they are the only ones who can change it. That should make you stop. The Rule of Four is the internal threshold the Supreme Court uses to decide which cases it will hear. Every year, thousands of petitions arrive at 1 Street asking the justices to take a case. The court accepts roughly 60 to 80 of them. The ones it refuses stay refused forever for most practical purposes. The question of which petitions survive that filter comes down to one simple, never-enacted standard. 4 justices must agree a case deserves a hearing, not a majority. Not a supermajority. 4 out of 9. A minority decides what America's highest court will answer, and this rule is written nowhere. It emerged from a closed-door meeting in 1924, the year before the Judiciary Act of 1925 gave the court discretion over its own docket. Chief Justice William Howard Taft, the only person in American history to serve as both President and Chief Justice, persuaded Congress to hand the court the power to choose its own cases. What Congress handed over was the authority. What the justices handed themselves privately was the procedure. The Rule of Four was never published. It was never formally adopted by resolution. It was agreed upon by men in a conference room, the public was not allowed to enter, and it was passed down to every subsequent justice as an unspoken norm. The first time anyone outside the court committed it to writing was in the late 1940s. The rule was already more than 2 decades old before most Americans even knew it existed. Here is who controls it now. The justices themselves, sitting in conference with no clerks present, no recording, no transcript. The only notes are kept by the most junior justice, who also answers the door if someone knocks. Every vote to accept or reject a case happens in complete secrecy. No justice is required to explain a denial. When the court issues its Monday orders list and your case doesn't appear, you receive one word: denied. Not a reason, not a dissent. One word. And because the Rule of Four is internal policy rather than law, a sitting majority could raise the threshold to 5 tomorrow morning and no one could stop them. Congress has no mechanism to intervene. The threshold that controls your access to the highest court is set entirely by the people who benefit from controlling it. Remember, no one voted for this. Think about what that means for a real person. In 2020, dozens of petitions reached the Supreme Court challenging qualified immunity, the doctrine shielding government officers from civil liability, created not by Congress, but by the court itself in a line of decisions beginning in the 1960s. Civil rights attorneys argued the doctrine was incorrectly decided and needed to be corrected. The court had the power to take every one of those cases. It declined them all. The Rule of Four had been applied privately, and the outcome was silence. No hearing, no answer, no correction. The people bringing those cases had no way to know how close they came. They had no right to know how close they came. The vote count in conference is never disclosed. The doctrine that shielded officers from accountability survived not because 5 justices voted to preserve it, but because 4 justices declined to question it. A threshold no one legislated, applied in a room no one enters, produced a legal outcome that affected millions of people. And here is the part that should actually worry you: it is completely legal. The Rule of Four cannot be repealed because there is nothing to repeal. You cannot strike down a tradition. The Administrative Procedure Act governs federal agencies. The federal rules of civil procedure govern trial courts. There is no equivalent framework for the internal customs of the Supreme Court. Article III of the Constitution creates the court and gives Congress authority over its appellate jurisdiction, but Congress has never used that authority to regulate conference procedure. No court has jurisdiction over the Supreme Court's own procedural choices. No inspector general reviews the conference room. There is no appeal from a cert denial. The structure is a closed circle, and the Rule of Four sits at the center of it, enforced by nothing more than honor among 9 people who were confirmed for life. If one internal tradition can silently control which constitutional questions the country is allowed to answer, ask yourself what other traditions operate exactly the same way. The assignment of majority opinions, the order of oral argument, the unwritten customs around recusal, none of these are fully codified. All of them carry the force of institutional reality. The Supreme Court is not simply a legal body. It is a self-governing society, operating inside a constitutional framework that never anticipated it would need rules for its own rules. The rule of four is not the anomaly. It is the example, which means the more important question is not how this tradition came to exist without a vote. The more important question is how many other traditions are shaping your rights right now. In rooms you have never been allowed to enter, under rules you were never supposed to find.